Some of the common misconceptions of estate planning are, oftentimes people believe that your spouse has the ultimate right to all of your assets, and that your spouse has the right to make all decisions. Well, that's not necessarily true. If you don't have an estate plan, or a written will, or even a will that complies with the requirements set forth in Massachusetts, that may not necessarily happen. Massachusetts has a program or a system called intestate succession, in which they set forth who gets what, and what person has what we call priority of appointment. What person the Commonwealth of Massachusetts believes will be the one that administers your estate and makes decisions on your behalf. So one of the misconceptions that people think is that by virtue of the fact that you're married to the person who died, we call that the decedent, that you automatically have priority of appointment. Another misconception that people have is if you're the child of a person that you automatically inherit. While this is true if you are related by blood, oftentimes if you have stepchildren and you don't have a written estate plan, those stepchildren don't have a right to inherit. I have a client that came to me and her father had died and she had 6 other siblings. Those 6 siblings she was raised with. And when it came time for each of those siblings to inherit, 5 of the 6 didn't inherit. Because those 5 were from a relationship of her mother or stepmother, and stepchildren don't inherit in Massachusetts without a will. So a major misconception that people have is that stepchildren will inherit if a person doesn't have a will under intestate succession. Call us today.